A very warm hello from Amsterdam. I'm Pasquale Pistone. I'm the academic chairman of IBFD, and I'm here with my colleague and co-director on the Observatory on the Protection of Taxpayers' Rights, Philip Baker, and we are here to share with you some comments and an overview of the latest release of the annual report by the Observatory, and that is the report on the 2022 developments. Philip and I will guide you through these developments, and I think it's interesting for us all also to understand whether there have been relevant developments in the past year and what those developments have been. We'll give you an overview of what might have happened, but of course you are welcome to take this video as an introduction to the report, which is fully accessible online and in open access, and also we will provide a more specific analysis of a couple of points that we have selected, and we hope that this will be of interest to you, just as any other activity connected with the protection of taxpayers' rights at the international level. As you might remember, Philip and I have started the concept of the Observatory at the moment in which we perceived that there was a strong need to monitor what was happening in the world in connection with taxpayers' rights, and also when we perceived that there is a need for a global dialogue on those issues. Since the 2015 general report at the IFA conference, we have started monitoring the developments in the framework of the Observatory, and every year we come up with this report. As you might remember, our goal is not to tell countries what they should do or should not do, even if we do have a list of 12 points or 12 areas where we have identified the best practices and also the practices that do not comply with the minimum standards of protection. Everything flows, everything changes from year to year, and the good thing is that our observatory has become a kind of traditional feature of international taxation. More and more people are using that. That can be used before courts, can be used by tax authorities for improving their practices, by the legislator to look at things which might be interesting, and also by taxpayers for securing an effective protection taking into account the standards. We have a selection for you, and I think that time has come for me to hand over to Philip Baker for the overview of some of the issues which we find meaningful. Philip.
Pasquale, thank you very much indeed. I find each year when I read the yearbook that it's a fascinating insight, because it's so difficult to get an overview of what's happening around the world on the protection of taxpayers' rights. And the yearbook, based as it is on 56 different reports covering 43 countries, gives you some sense of the direction. And overall, I would say the impression I get of 2022 is that it was a year without any major changes, either positive or negative, a number of small changes that have either improved or in some respects, unfortunately, perhaps slightly reduced the protection of taxpayers' rights. Overall, the year seems to be in balance, with maybe a little bit of an improvement overall, but with some sliding back away from minimum standards or best practices in a few countries. One of the trends that I particularly noticed in this year's report was the continuation of the sort of consolidation of measures that were implemented during and as a result of the COVID pandemic. So a number of countries had to introduce more online dealing with taxpayers, more filings over the internet, and that has been continuing with an increased amount of e-filing, an increased amount of online assistance to taxpayers, and that's very positive to see taxpayers being given more online assistance, but also a realization that some taxpayers have difficulty accessing the internet. And so for those, there is a necessity to also provide other ways in which they can get guidance from the tax authorities. At the same time, there's also some very positive developments with regard to protecting confidentiality of taxpayers, given the amount of information that's being supplied. Some of the most important developments have occurred in Latin America, and that may be possibly because we have some very, very good reports from countries in Latin America. But for example, in Chile, the establishment of DEDECON, a new Office of the Public Defender of Taxpayers, that's clearly a positive development. The best practices on, for example, data management are becoming clearer, and one of the things that comes out from the report is that we must start looking at some new areas of the interrelationship between tax authorities and taxpayers, data management, the handling of big data, and particularly the use of artificial intelligence. These are matters that we need to develop. If I were to highlight a couple of other areas, there's been some very important cases from the European Court of Justice, the CJEU, on the application of the Charter of Fundamental Rights to taxpayers, and some significant decisions of the European Court of Human Rights, including some Grand Chamber decisions. Generally, one finds it a bit disappointing that the European Court, maybe because it has a focus on more egregious issues of treatment of citizens in the countries, perhaps provides less protection than one might have hoped for. There have been some small regressive developments, particularly with regard to retrospective legislation, where a few countries have strongly confirmed the non-retrospectivity of tax legislation, Bolivia, Spain, but in other countries there has been a tendency to make an announcement and then to apply the legislation with retrospective effect. Exchange of information, there's been some developments in that area with regard to, for example, limiting the exchange with other parts of the government, some developments in Brazil on that area. In Europe, the issue of ne bis in idem, double jeopardy, which in the tax context is reflected in a taxpayer who has, for example, evaded tax, firstly being liable to an administrative penalty and then being liable to criminal sanctions as well. We have in a number of countries working through the decision of the European Court of Human Rights in AMB versus Norway, and we see developments, for example, in Belgium, again a consequence of COVID, in a number of countries, the development of rules that allow taxpayers who cannot immediately pay their tax liability to agree a deferral, which is an important position, so the taxpayer is not made bankrupt because they can't immediately pay their taxes. Finally, one point that particularly I noticed was on the question of charters of taxpayers' rights. There are no new charters, nor has any country withdrawn its charter, so that's sort of neutral. But for example, a country like Australia has reviewed and strengthened its Charter of Taxpayers' Rights, but then that's balanced on the other hand by the fact that our colleagues in Łódź in Poland have drafted a Bill of Taxpayers' Rights, and for the third year running the Polish Parliament has declined to debate that bill. So that's an illustration of how generally matters have been in balance, with some improvements in some countries, some slightly regrettable steps in others, but overall the report indicates a fairly neutral year with just some overall improvement. But you want to talk, Pasquale, about a couple of very specific developments.
Yeah, Philip, I thought that it could be meaningful also for us to share some specific developments concerning, in particular, client attorney privilege and the right of access to justice. And these are issues which we keep seeing from year to year as being critical, and that we see that something needs to be done in that context in order to achieve some fair balance between the effective protection of taxpayers' rights and, of course, the right of tax authorities to secure a framework within which they can obtain an effective tax collection. Now, this point of mandatory disclosure, which is one of the results of the international tax coordination framed in the context of the BEPS project, and also as the outcome or legacy of global tax transparency, is a matter that is difficult to properly to have properly operating in practice. The point is that essentially the object and purpose of mandatory disclosure is that tainted schemes, tainted of tax avoidance or of non-compliance, must be revealed to the tax authorities from beforehand. And this is something, it's an obligation which is established both on taxpayers themselves and all intermediaries and third parties that come across some information. Now, my personal impression is that the standard for mandatory disclosure might be rather blurred in some cases. We know that the whole experience of the hallmarks shows a number of issues which might give rise to tainted schemes of tax avoidance. But the very fact that we have so many is creating legal uncertainty. Now, the point is that one can say, well, you know, the more tainted scheme, the more tainted situations we have, the better it is for tax authorities to come across possible critical issues. But at the same time, my impression is also that when there are so many issues which might have to be reported, then we are perhaps causing some kind of flooding or structural flooding of information. From the perspective of taxpayers' rights, the issue becomes also complicated because of the right of the taxpayer to have a free flow of information with the attorney. And this is just an expression of the general client-attorney privilege. Now, the client-attorney privilege was, of course, not conceived just to operate in tax matters. But when we talk about the client-attorney privilege, we have to understand that in tax matters, there are a number of complex issues that may arise. Number one, because the information is not just in the hands of the attorney, but it can also be in the hands of any tax consultant or third party that comes across that type of information. And there can be issues, number one, because some countries protect the client-attorney privilege for information in the hands of the attorney and the client, but not in the hands of other persons that are involved. So if we want to secure an effective protection of the flow of information, let's say of confidentiality of information between the client and the attorney, we have to make sure that there is no gap or no other possible unintended area left without an effective protection in the hands of third parties. At the same time, it's difficult to reach a balance between the two interests here, because we also want to make sure that tax authorities come across all relevant information. And there we go into the spirit of mandatory disclosure. But in fact, as practice has been showing during the year 2022, there are enormous difficulties that have brought some countries to suspend the functioning of the mandatory disclosure. And I think it's emblematic for us to quote the case of Argentina. And this is something which has, popped up from judicial practice and has produced repercussions, and as you will be able to see from our annual report, has produced some repercussions which first led the Argentine tax authorities to suspend mandatory disclosure and then, to just block it because of problems of professional secrecy and violation of professional secrecy. So I think that this is something which is recurrent. I should say it's not something new for 2022, something which we have seen also at an earlier moment. But this is not just a matter, an isolated matter. We see that the same critical issues also arise in other parts of the world. And I want to compare this data about Argentina with these developments concerning Argentina with developments concerning the European Union. And in the European Union, we had a judgment by the Court of Justice in the Orde van Vlaamse-Bali's case, C694/20, which has clearly indicated that there might be critical issues for Articles 7 and 47 of the EU Charter on Fundamental Rights, insofar as there is an obligation to disclose information on the intermediary lawyer. So I think that it's also important to see this in the future perspective, because this is not let's say the last case in the pipeline at the Court of Justice, even if a case from France has been withdrawn from the Court of Justice. But still, there are more pending cases from Belgium, including one from the Constitutional Court. And this also shows that it is important to secure an appropriate balance between the collective rights which are reflected in the power of tax authorities to secure an effective tax collection, and the fundamental rights of individuals, which should never be sacrificed on the altar of securing the effective collection. And I think that, Philip, this reflects also our view of becoming engaged in the technical dialogue on the protection of taxpayers' rights, that it is really important that we strike the right balance between the collective view of human rights and the individual view of human rights, which might be harmoniously reconciled. Now, that was one of the two areas in which I felt it could be important for us to share some more in-depth analysis with our colleagues from around the world, just to stress the importance of critically verifying whether in their countries this fair balance exists or not. But
before you move on, perhaps I might point out that this issue that came to a head in Argentina and in the European Court case has actually been one that in a sense was always foreseeable. The mandatory disclosure, the system that was adopted by the OECD, was essentially based upon the UK DOTAS system, Disclosure of Tax Avoidance Schemes. And when that was first introduced in 2003, one of the questions that came up was what happens if the information is in the hands of a lawyer with legal professional privilege, attorney-client privilege, and how do you deal with this disclosure? And the solution that was come up with at that time was for the lawyer to transfer the obligation to disclose to the client or to another non-legal professional. Whether or not that provided an adequate protection was always an issue. And so, okay, we had to wait almost 20 years, but ultimately we are getting the answer that no, there is not an adequate balance in these situations. I thought I'd just add that little comment that what was shown in the Observatory this year is the answer coming to a question that was originally posed 20 years ago.
Yeah, and I think, it's actually quite important, and it gives us, even more motivation, Philip, to keep monitoring what happens around the world, because sometimes problems that arise in one country can be properly addressed by taking into account the legal arguments that are developed in other contexts. Now, let me move on to the second topic of this, of our in-depth analysis, and that is the right of access to justice. And I think that this is also an evergreen of the protection of taxpayers' rights, but I will be a little bit shorter on this point, because I think, the essential point is that the right of access to justice may not be made conditional upon the payment of a tax. And theoretically, this is quite clear, but in practice, it seems that it is not. So we have a few developments, again, from the European Union and I should say from the European region, because this time I'm referring to a European Court of Human Rights case, the Vourika Save versus Greece, number 78572/17437 of the 7th of December 2022, concerning the right to fair trial. And we're having some more developments from Latin America once more. Indeed, I agree with you that there seem to be quite many developments in Latin America. We do have reporters from around the world, but maybe this is an issue where more critical issues might arise in some areas of the world. But let me be quite brief on this judgment from the European Court of Human Rights. And that there was a problem with a taxpayer, which was a company, and that had declared bankruptcy and ceased its function. Now, the interesting feature here is that after the first judicial instance, the system of the country required the payment of 50% of the imposed tax or fine for accessing the second level, the second judicial instance. I must say that this is not so uncommon in a number of countries, in particular when the judgment from the Court of First Instance is in favor of tax authorities. And that is something which can to some extent be related to the likelihood of the fact that there is, the tax authorities have a point. But still the Court of Human Rights said that the fact that in this specific case, because of the bankruptcy, the taxpayer was not in a condition to make that payment, in fact deprived the taxpayer of an effective protection. And that is certainly something which arises in sort of borderline or critical cases. But again, right of access to justice means that you have the right to a final judicial decision without an obligation of prior payment of taxes. Here we have a positive development in Honduras in 2022, which has been reported, so goes in the right direction, that secures that also at the level of the legislation. And also a negative development this time from Argentina, which has established an extraordinary one-time prepayment on account of income tax payable by corporate taxpayers that have obtained extraordinary income derived from the general increase in international prices, so a windfall income tax prepayment. So again, in those cases, we have to remember that the effective consistence with the rights and principles has to be monitored. And this is what we're actually doing with our observatory. Something that we stress, I take the liberty of reminding that also on behalf of Philip in a non-judgmental way, but we want to be very granular and showing the world what happens in the world on international taxation, and in particular on issues which relate to the protection of taxpayers' rights, which is the primary focus of the observatory. This is being done by IBFD in the function of being the home of international taxation, and we hope that this input might be interesting for all of you, no matter where you are in the world, and we look forward to having you reading our report of the observatory and providing us with your comments, which are always welcome. Thank you very much.
Thank you very much.